Verity Egerton-Doyle, Tom Smith, Anush Ganesh. Welcome to Digital Markets Research Hub. Recently, there was a big conference organized by TL4 focusing on scrutinizing the emerging UK regime for regulating competition in digital markets. And Verity and Tom have been co-chairing this event. We were lucky to have Anush attending this event as well. The event was really remarkable. We have Skida project has published a blog post on it, and also there was other coverage as well. But it's unsurprising because the co-organizers are amazing, and the participants as well. I'm very grateful to all three of you for agreeing to share the reflections about the event itself, but also obviously to share your impression about the current regime in the UK. Maybe you can say a few words in comparison with the DMA as well, if necessary. But maybe let us start with reflecting on the conference, your impression, and the key elements of this event. Verity, please.
Yeah, sure. So thank you so much for having me on again. It was a really good day, as you say, and it was the third time that Tom and I have chaired this conference together for TL4. It was the first time we've chaired it when the legislation was actually in force. So that made it very exciting because we actually, having been speaking about for the last 3 years at this conference, but for many more years than that, speaking about the regime that the DMCCA brought in, to finally have the powers in place and to have the first cases, we had a lot to talk about. So it was really interesting. And we covered over the course of the day kind of every aspect of the strategic market status regime, which was introduced, but we also covered the interaction of that regime with other parts of the CMA's function, including those which were enhanced by the DMCCA. So we had a very interesting discussion about consumer law and the implications of that, particularly in the digital space, the interaction of that potentially with the SMS regime. We also discussed, what this regime means for the future of abusive dominance enforcement, in particular in the tech sector, as well as what the regime means and what the reforms mean for the role that the courts are likely to play in enforcing these points in future. So, I mean, Tom, you probably have more to say, but it was a pretty comprehensive run through of everything DMCCA for the third time, but this time not just talking about what the law said and what might happen, but also about what has been happening.
Yeah, completely. I mean, yeah, Thought Leaders Ford does, they organise very nice conferences actually, and it has a range of viewpoints. Some of these legal conferences only really have defendant kind of firms speaking, so it's nice to have a range. Makes for a bit more of a spicy conversation sometimes. So we had some good panels. One of the best panels was probably the in-house perspectives. So people always like to hear from the companies that are they're fighting these wars, and we had Google represented, as well as kind of challenger firms, vertical search firms, and other firms that are kind of pushing for changes in how the tech sector operates. So it's an excellent conference. Yeah.
Great, thank you very much, Anush. What were your reflections? You have published them in a blog post. Maybe go beyond.
Sure. Thank you so much for the invitation, Alice, and well done to Tom and Verity on an excellent conference. So, in my opinion, the conference provided a very good overview of the UK regime currently. So, as Tom just said, I think it was really interesting to see perspectives from different sides, from big tech, from opposition businesses, from practitioners and regulators as well. So I think from what I saw, some of the key topics that Verity also already mentioned was on the SMS investigations, on the procedure as well in terms of the 9-month period for designation of gatekeepers. Some of the other interesting conversations were had on regulatory coordination between the CMA, Ofcom, the payment systems regulator, in aspects such as digital wallets, cloud services, etc. Some of the persistent themes were, again, the speed of enforcement and versus the thoroughness of enforcement. Because now the CMA is engaged with 200 plus stakeholder responses in mobile ecosystems and in Google search. This demonstrates very good commitment to this evidence-based decision making, and again this bespoke nature of the DMCCA, which I'm sure we will touch upon later on. There was also this very interesting discussion on how smaller businesses mentioned that they cannot wait for lengthy regulatory processes. Also, consumer organizations seconded this. Whereas some of the other bigger firms, they did note that taking action where industries are still developing, that might be overkill or overreaching the clutches of the law. So we do need to be very cautious in terms of how we utilize the law here. So I think some amazing discussions by virtue of having a variety of different views in that conference.
That last point is an interesting one, Anish. And it's just been weaponized hugely effectively over the years. It's Verity's going to
You
tell
would
me
say that.
I would, and I did. But if we don't mind what you do. It's just that you haven't quite proven your case. If you just did a little bit more work, if you just waited for the market to develop this much further, then maybe you can intervene. But until then, no, you shouldn't intervene. And of course, that goes on forever. And that's why.
Tom, that is, I think, I mean, I know what you're saying. Of course, clever lawyers are always going to use whatever arguments they can, totally in a way that is, of course, legitimate and is the basis of our system. That we each make different arguments. But I do think that, and I don't want to completely sidetrack us, but I think that argument that people were saying this for years and then look what happened with Web 2.0, I do think we're in a different place now with AI. I think things are, the pace of change is actually much faster than it was previously, and the scale of transformation brought about to the entire economy by AI is, I think, something which did not happen during the Web 2.0 era. And so I think, I see why people roll their eyes a little bit about saying, well, no, regulate us tomorrow, wait and see what happens with the market. But I do think there's a real dynamic at the moment where there are real risks of intervention and kind of taking interventions that are not too late because the harm is done, but kind of too late because the market's already lapped the regulator, and then there are huge risks of distortion. But anyway, that is a different discussion. But I couldn't let you say that without giving
quite right.
Speaking yet of the regimes, let me ask you. We see how much is going on with the DMA. We know that that UK regime was with Furman Report, Furman Review was a front runner, and overall with CMA, with online platforms and digital advertising market study, remarkable in itself in terms of eye-opening for many. We are still in the designation process. It takes months, statutory requirement, and then we will be discussing the conduct requirements. Is it bug or feature, Verity?
So I think it is very much a feature of the UK regime that the conduct requirements are designed for each individual business, and the objective being that they can be more targeted, more proportionate, but really critically also more effective at actually solving whatever the harm is. So I think that is very much a feature of the regime. I mean, Tom should know because he helped write the report on which it's based. But it does, as you say, mean that it's much slower than the DMA, and it's also kind of quite important in the current moment. It's much more susceptible to changes of changes of the wind in terms of the level of appetite for intervention. So, if you think about the DMA, the rules in the DMA are in legislation. They were written by the European Parliament, and to be changed, the European Parliament is going to have to change them. Obviously, that's a blank. There are some nuances there, but if, for the most part, Parliament wrote the rules, and you have to go back to Parliament to change them. Here, it's the CMA that is writing the rules. So we are, we're 10 months in to this legislation being in force. We had the first designation decision just last week in relation to Google search and search advertising. We will have the next 2 designations next week, assuming that they are designations in relation to mobile ecosystems of Apple and Google. But even with Google now designated for search, there are no rules yet, because we're now going through the CMA will consult on conduct requirements later in the year. All of that is, to ensure that the remedies can be targeted, effective, and proportionate, but it does mean that they're slower. Look, I think that actually, given the UK's place in the world, I don't think it's a bad thing for us to have the advantage of actually being able to look at what's happened under the DMA, see if it's effective, and take the learnings of that in writing rules for the UK. Take where things work, adopt them; where they don't work, or where we think they're disproportionate, or the disruption to business, the disruption to innovation is greater than the benefits that they deliver to users and consumers, then I think it's right that we don't adopt them. So it's a feature, but of course it comes with trade-offs.
Thank you.
Yeah, that's right. I mean, so yeah, when we were designing it, it was definitely the feature, but we definitely knew it was doing it the hard way in the UK. I mean, the CMA has to prove every single designation in a, what was it last week, 156-page report to explain that Google search has market power, which is quite, you would think, an easy one to prove. And then we'll get the appeals, of course. So it's definitely the hard way. And then they have to prove that every conduct requirement they want to impose is proportionate and fulfills one of the statutory objectives, whereas the European Commission, used bright line thresholds in terms of user numbers and all that to get designations off the ground, wrote at least the outlines of the requirements in the DMA. Now the European Commission is, Europe got it on the statute books nice and quick, but is now in a pretty difficult phase, which was inevitable and a feature of that framework, where you get they're asking Apple and Google and the rest to say how they are going to comply, and then they're saying, well, that's not good enough, try again. And so you're in this kind of cat and mouse game, which was inevitable, we just have to kind of let it play out. Apple's in court next week appealing its designation in Luxembourg, I think, and my firm's intervening on behalf of the Commission for a client. So it's all working its way through. Now, the trouble with the UK regime is that it's now been discovered to be subject to outside influences, and that's something the European Commission actually is arguably less susceptible to. It was an almighty slog getting it on the statute books. At least it's on the statute books now, and if it is going a bit slower and a bit weaker than it should, then that's just the way it is. It's on the statute books now, and we can start building on it over time.
Thank you very much, Anush.
I think the DMCCA is fundamentally different because, again, it's quite evidence-based and it's quite bespoke compared to the prescriptive nature of the DMA. So my perspective is completely academic. And in that perspective, I think I find that the UK approach is quite thorough. So at least seeing this 156-page report that Tom alluded to, the Google search designation, I think what they've done is they've incorporated all the consultation responses. They've incorporated so much evidence from different sources, even Google's own responses, as well as other stakeholder responses, which shows that the CMA has taken into consideration whatever was provided to them in terms of the consultations. This includes also academic responses. So I saw that the responses by Fiona Scott Morton's team and Anya Schifrin's team have also been included in the final decision. So it just shows, I think, the kind of thoroughness that the CMA is taking with regard to, let's say, designating any kind of service in itself. Now, also a point that Verity alluded to, the uniqueness of the DMCCA is also in its bespoke nature. So Owen McMillan, the senior director of the DMU, at the conference said that the focus on the app distribution conduct requirements would be such that Google would be imposed conduct requirements on fair and transparent ranking, whereas Apple would need to address interoperability issues for app developers. So we can see that within the mobile system designation in itself, the two firms would have different conduct requirements. And this is something that the senior director had mentioned, which I thought was quite interesting. So also shows the uniqueness of the DMCCA. Perhaps it might not be unfair to say that under the DMA regime, it would be the same set of requirements that would bind Apple and Google if they were designated under, let's say, a certain criteria as gatekeepers under Article 3 of the DMA. So this also shows quite a distinct approach of the DMCCA, in my opinion.
Yeah, it's an interesting point you made about the report itself, because actually one of my colleagues in Germany read the report over the weekend and said, and he said it's amazing how much the CMA refers to the things Google said and kind of adopts them wherever it can. And we were talking about it, and actually I think it's just stems from the English legal system. The report is subject to judicial review rather than merits, and so the CMA very much has to show that it took account of all the evidence it received. It's a pretty slam dunk judicial review case if the CMA ignores a relevant submission that Google made. So it's very kind of deliberative, kind of going through all the things that are said to it, which doesn't make for a snappy report, does it? But at least it's a thorough process.
Yeah, but I think in turn it also, I mean, a dynamic part of a global dynamic is that because the CMA writes up these really detailed, reasoned decisions on, and this applies across all of the CMA's functions, but I think it might prove to be very important, in particular in the digital space. Because of this practice, I think it means that the CMA has, outsized influence globally, because its reports are, they're well written, they include the evidence, they're easily digestible. That means they can be picked up. It means other regulators can look at them. It means people like your firm, Tom, can pick them up and try and, start class actions off the back of them. But I think it does mean that, even though the UK is just one relatively small country, I think the work the CMA has done here is going to be very influential more broadly.
I think we have already started comparing both regimes, sister regimes. But can we? I would like to ask you a question directly. We see that it would be an overstep or kind of a caricature to label the DMCCA purely bespoke, discretionary model, whereas the DMA kind of quasi-automatic. They both are relatively constrained and relatively flexible, but to a degree, the DMA is much more automatized than the DMCCA, as you have alluded already. So I was wondering, at what point would you do you think that given the agility or urgency of many of these kind of challenges, which we were hoping that these regimes will address, on one hand, we need the bespokeness because it's all kind of case by case, and each business model is different, each conduct is different, and each remedy should be kind of tailored accordingly. But on the other hand, we see how high the standard of proof is, even conceptually, in all stakeholders in the UK. And the reliance during the discussions of the bill, the reference to proportionality would be automatically somehow attributed only to critics of the DMCCA, because the very regime is disproportionate, it's asymmetric ipso facto almost. I understand that. So can you allude, please, what is the role of proportionality in terms of juristic requirement to UK legal system and any legal system, of course, but in the UK specifically? And where would you strike this delicate, where would you put the cursor between the automaticity and bespokeness? Verity, please.
Do you want to go first, or shall I? I can go first. So
Yeah.
the word proportionality wasn't in the first draft of the bill. It was inserted following parliamentary processes when the government was trying to include extra kind of checks and balances to kind of satisfy the possible SMS firms. Now, of course, it would have been part of the regime anyway under the appeal process, but now it's explicitly written into the Act. I would say it's important not to overinterpret the word in proportionality. If you get too hung up on it, you end up not doing any interventions at all, and you get type 2 errors rather than type 1 errors. And I think that's the trap that I worry the CMA will fall into, because if you're in a more timid place and you're under a lot of scrutiny from the government, I think it's quite easy to kind of retreat into using the word proportionality to mean you don't really do anything at all, or at least anything that makes a practical difference. But there's good case law from the Competition Appeal Tribunal about what the word means. If you've got lots of options that are effective, then you need to pick the one that's least intrusive, least onerous. And so that's pretty kind of clear. Hopefully, we'll start getting some cases through, and we'll have a better idea about exactly how the CAT is interpreting that in this context.
Thank you, Verity.
Yeah, I mean, of course, both the European Commission. The European Commission is obviously bound by proportionality. The CMA, as Tom's saying, has a duty to be proportionate in the way it exercises its functions as a general matter of law. But I do think that the inclusion of the word proportionality, so for those who didn't follow every twist and turn in the legislative process, the earlier draft, the first draft of the legislation, said that a conduct requirement could be imposed if it was appropriate, whereas the legislation now says that it must be proportionate to achieving one of the objectives that are set out. I think that is important. I think it's an important distinction, because I think having that specific duty of proportionality and having it written into the legislation, I think there is some of that good case law you're talking about, Tom, that does say that the precise wording of the legislation is important in the way that you interpret the duty. And so I think that is important, and I think especially in these these markets which are very fast evolving, and where there are I think there is more scope for unintended consequences than in some other more kind of static markets. I think that is really important to to have the CMA specifically focused on what are those trade-offs. I mean, as you say, Tom, of course, doing nothing is a decision. People think doing nothing is not an intervention, but it is a decision to do nothing. So there are costs of doing nothing just as much as there are costs of doing something. But I think it's good to focus the attention on actually what the costs are on each side, and what the risks are that you're accepting.
Yeah. Of course, just on the fast-moving point, I mean, the things that the CMA is currently proposing to regulate, which is search and app stores and stuff, these haven't changed in 15, 20 years for the most part. Some of the self-preferencing stuff that the CMA's considering doing in category 2, which would be in early next year, that's coming out of the Foundum complaint back in 2009. Very little. I mean, the superficially it's changed, but very little of the actual fundamentals have changed. And whereas the CMA is not planning to look at the Gemini chatbot as part of its designation. So I think the CMA is being quite targeted in terms of choosing, the things that actually aren't developing at kind of breakneck speed. So hopefully that kind of concern won't arise.
So, I mean, you're right, they're not looking at the Gemini chatbot. but they are including AI overviews and AI mode in search. And so I think, you know, there is a recognition of a level of change. And like you say, you know, the CMA's adopting a cautious approach. But I think the advantage of, you know, it is a real strength of the regime that the CMA can take all of this into account. And we can see now what's happening with the DMA, kind of the review of the DMA. And you can see that they're really grappling with, you know, how do you address AI in this framework? Is it as part of one of the existing core platform services? Do we need something else? And I think you can see that it's a strength of this regime that the CMA has that flexibility.
Anush?
I don't have a lot to add, but I think the only fact in terms of proportionality itself is just assessing the needs of the smaller businesses in terms of, again, a speedy action by the CMA in terms of what results they want, and contrasting them with some of the issues that Verity has alluded to now in terms of overaction and whether if taking action too quickly might end up costing the overall industry later on. So that is something that I think the CMA has to balance quite carefully, because these needs of the smaller businesses are quite important. I think from the conference, one key thing that I did pick up was some of the smaller business representatives. They said this is survival for us, whereas for the big tech firms, well, it's just one small aspect. So it does put things into perspective in terms of what the CMA is dealing with. So proportionate action, I think, is a very key aspect in terms of what the CMA has to now engage with.
Let us now revert to engage in a forecast game and try to imagine how the first conduct requirements will be designed. We know that the specificity of the regime is that the CMA has, I wouldn't say carte blanche, but the provisions of Section 21, 22 are quite generous. Oh, again, depending, maybe we are now in the different phase where they could be seen as very constraining as well, I imagine. But yeah, so that's part of the question. How far the CMA can go, how big is the appetite, how this conduct requirement might look like in the first designation, after first designation and first designations.
Covered.
Yeah, well, I mean, one initiative that that the CMA has brought in, which, you know, wasn't required by legislation but was written into guidance, was this very helpful initiative to publish a roadmap of what the interventions would look like. They did that for at the time of the provisional decisions in both of the search and the mobile ecosystems cases. I mean, we had a debate at the conference about how useful it really was, and I think, you know, in particular, you know, there were some representatives who were saying we had really hoped that what the roadmap would be is it would be taking things off the table, and that the CMA hasn't really taken anything off the table in the roadmap. They've just listed all the possible interventions they might take with a sense of priority. But I mean, what that does mean, to the direct answer to your question is of what will the first requirements look like, you know, I think if you look at, for example, the Google mobile ecosystems case, the CMA has published, you know, category 1 first priority interventions will include requiring that Google reviews apps to be distributed in its app store in a fair, objective and transparent manner, requiring that it ranks apps in its app store in a fair, objective and transparent manner. These are kind of the requirements that you were picking up earlier, Anush. So and then we have a sense also of, you know, what's coming next and things that the CMA isn't minded to prioritize for now. I think one thing that is very interesting is the approach that the CMA has taken in those roadmaps to some issues that are really much more global. I mean, in a sense, all these issues are global because they're global platforms, but there are, you know, some issues, especially around search, where there are parallel cases in the US, and you know, in between the provisional decision and the final decision on Google search, we've had major developments, of course, in the search case in the US in terms of remedies. It will be really interesting to see what the CMA now chooses to do, because they had previously said, well, we're going to wait and see what happens in the US. We now kind of have that outcome. They haven't said in the final report exactly what they're going to do yet. I suppose we'll hear from them in the next few months. But I think it's really interesting and goes to kind of global coordination and what is the role of this regime and the role of the CMA in the bigger global picture.
Yeah, sure. Yeah, so the CMA kind of split the remedies into kind of 4 different categories, with category 1 being the only category that's going to be implemented in the kind of near future, really, and the rest are more vague. So on Google search, it was pretty disappointing that the US judgment did not ban these $20 billion kind of payments from Google to Apple for default positions. So that does put the CMA in a difficult position there. That's always been kind of remedy number 1 in my mind. And the kind of absolutely obvious, well, even if you weren't doing anything else, you'd do that. But and that's in fact what the CMA Market Study Report July 2020 says, that these defaults are bad. So we'll see if the CMA departs from the US outcome. It has plenty of basis for doing so. The US outcome was very narrowly focused on the specific infringement finding in that case, whereas the CMA has much broader powers as long as it's satisfying one of those 3 statutory objectives that you referred to earlier, Liz. So it certainly has the legal powers to ban defaults. It has the moral powers to do it because it's spent 5 years saying it needs to be done, but I suspect they won't do it for the time being. So what we're left with in category 1, probably the most notable one in my view would be the crawlers, separating Googlebot, so that publishers, website operators can opt out of the AI overviews and AI mode bit of Googlebot, and therefore exercise more control over what happens to their content. I think that's a really good remedy, and it was listed in category 1 for the roadmap. Again, it wasn't part of the US judgment, but that's because it wasn't part of that case. It's not that the US judgment said it was a bad idea. So we'll see that, and various other things. And then, yeah, so next week we're due to get the Google and Apple mobile platforms designations. And then, so the remedies on that, again, disappointingly kind of staggered from the challenger side's point of view. The most, I would say, the most useful one in category 1 is the prohibition of the anti-steering provision in Apple's App Store rules. So that would hopefully mean that an app developer can steer a user off Apple's platform in order to complete their subscription or their purchase. That would remove Apple's ability to charge its monopoly rents, well, if it depends whether Apple is allowed to charge anything at all, but certainly the app developers would say they shouldn't be charging for where a user is steered off, because that's when Apple is not providing a service. So the steering stuff, and that, by the way, is already being imposed in the US. So that would, the CMA could tuck behind the US judgment quite neatly there without sticking its neck out. So that will hopefully happen, that one. And then the other kind of big stuff is the kind of things like alternative app stores, which has been shoved into category 2. So that won't be consulted on until next year. These timetables only ever slip further away. So I would be amazed if we see a consultation on alternative app stores in the first quarter, but we shall see. Anyway, so it's a kind of ongoing debates. Timetables always slipping, but hopefully we'll get there in the end.
Thank you, Anush.
Just to add to what Verity and Tom have said, I think they've covered it quite comprehensively. But I think I also wanted to mention publisher control mechanisms, because this is something that I saw quite vividly in the stakeholder responses in both Google Search and Apple and Google mobile ecosystems. Loads of publishers had responded, as well as at the conference itself. I think Matt Rogerson from Financial Times also alluded to the fact that publisher control is quite important, and how AI overviews are disrupting their businesses. And I think including AI overviews within SMS designation also makes sense in this particular respect. And as Tom said, I think this would be one of the first conduct requirements that we may see. along with not self-preferencing and data portability provisions, as mentioned in Category 1 interventions. Now, I think these would be fundamentally what we would see with Google Search and with Google mobile ecosystems. I think it would be quite interesting to see different sorts of conduct requirements for Google and Apple based on their different functions and their unique business models. And it is quite important to note that the mobile ecosystem market itself contributes about 1.5 to 2 billion pounds to the UK GDP. So it'll be quite interesting to see how the conduct requirements are designed to make sure that this thriving industry is not disrupted in any manner whatsoever. One point that did come to mind is also this timeline of imposing conduct requirements. Now, while there's this 9-month deadline from beginning a SMS investigation and to ending it, which now the CMA has carried out 4 days before the conclusion of the Google search designation. And as Verity mentioned, they'll have to do it also for the mobile ecosystem designation sometime soon. There isn't any kind of deadline to start the process of looking at a conduct requirement post designation. So perhaps there's also a question to Tom and Verity and to yourself, Oles, in terms of whether this is something that I don't know the CMA has missed out, or whether this is just an active exclusion, which does make sense.
Yeah, the deadline for the conduct requirements, we certainly argued that there should be one. And the CMA, during the legislative phase, the CMA actually pushed back, saying it wasn't necessary because they're going to do it quickly anyway. So that's quite funny. Anyway, so we haven't got one. So they could take forever to impose the conduct requirements if they want to. Yeah.
But they also don't have any, I mean, other than the need to consult on them. I think the flip side of not having like a deadline and really a prescriptive process that they have to go through is that it gives that flexibility that they can, they can do it in waves. They can come back and, if a conduct requirement isn't working, they can come back and they can rewrite it. They just have to, consult on it again. And so I think, we've been talking a lot about the trade-offs in the regime, but I think that's one of them.
Yeah, so the way the amendment would have been drafted is that the CMA would have had a deadline to impose a first set of conduct requirements, and then it could add and subtract as much as it wanted after that. But anyway, it's not in the Act, so it doesn't matter.
Okay, I'll have my opinion on this matter. It's a little bit more cynical, perhaps. I think that if the system was designated, once we abandoned the classic, the canonical belief in economics as neutral and objective science, we start realizing that competition is a political kind of, to some degree at least, or managing competition in digital markets is a political issue. I disagree with the normative choice of the government, but I think that the CMA has to be mindful of it. So I have mixed interpretation of the situation because I'm unhappy with it, but I think for me it's consistent with this kind of political DNA of competition policy. But
yeah. I mean, I think that's a really interesting point. Obviously, all competition policy is inherently political to a good degree, but I do think there's an interesting question when you're thinking about the CMA and the different functions it has about, how much political, I wouldn't say interference, I'd say, how much political influence the government of the day should have over what the CMA does with the various functions. And I mean, clearly in terms of prioritization decisions, that seems like something where you want that, they have the steer from the government and you would hope them to follow it. Then at the other end of the extreme, once a case is open and the CMA is applying a legal standard, you would expect or you would hope to have very little intervention with that. I think the SMS regime is really interesting in that it creates a quasi-regulatory regime. If you think about other sector regulation, there's much more governmental influence there than there has been typically in CMA casework. And I think it's not I don't think it's necessarily wrong for a regulatory regime which is kind of inherently redistributive and making political choices to be kind of operated in line with with what the government's policy of the day is, whether we agree with it or not. But I think the nature of the regime does makes it very different to some of the other functions that the CMA operates.
I agree. Let us move to the issue, which again has elements of toxicity. Even if at the very beginning, this idea of regulatory dialogue and a participative approach to doing business was one of the kind of overarching leitmotifs of the discussion. But currently, we see that people start associating regulatory dialogue with some lack of transparency. And so rather than I think I personally believe that related dialogue is and will always be the main toolbox for doing it effectively. But let me ask you, how do you perceive the role of regulatory dialogue in the UK regime, given in light of the circumstances which you have just reflected upon? Maybe we can start with you, Tom.
Yeah, no, it's pretty. So the CMA was very clear. It was going to be kind of getting out there more to talk to people in this regime than it does in, for example, a merger investigation, and that's definitely the right thing to do, and it's what it has done. I haven't had any difficulty getting meetings with the CMA whenever clients wanted to, and the CMA turns up and is extremely well informed and full of questions, so it's been a good process, I think, on that front. And that's important, of course, because as we've been talking about, the CMA has powers to write rules about how an industry functions, and that it's not just the SMS firm that is affected. It's lots of other firms when the new rule comes into place. So the CMA does need to make sure it's got all the right views from all sides. So there's definitely from my point of view, there's no complaints about the CMA's quality and knowledgeability and willingness to engage. The only complaint is, of course, the kind of always complaint about regulators that they move too slowly.
I think, I mean, Tom, that's a really good point. And just to highlight for anyone who might be watching and listening who maybe doesn't know everything about the kind of work that we all do, but I think, Tom, when you say I've had no trouble getting a meeting with the CMA to talk about this, you're talking about a meeting on behalf of I know you don't like me to call them third parties, because I've heard you say many times that these parties are just as affected by the decision the CMA takes as the designated or potentially designated firm itself. But I think that's important. I mean, that we all kind of wondered about, just in terms of bandwidth, in terms of 9 months sounds like a long time, but actually with the number of steps the CMA has to take in the process, it's really not that long to engage with people. But I think that people should take a lot of comfort from what you've said about, being able to get access to the CMA, to speak with them on behalf of third parties, or of the people working with designated firms or the counterparties of designated firms, and you can see it's apparent on the face of the decisions that the CMA has taken how much evidence they've gathered from not just the firm itself but from many others.
Yeah,
thank you, Anush.
So I think this regulatory dialogue process, it adds to the thoroughness of the DMCCA. Now, on my reading of the Google SMS final decision, between pages 26 to 62, saw several references to the responses to the initial consultation released on 24th of June. Now, that also led to material change in terms of the CMA's final decision, in terms of first of all, organic search syndication, refining the scope of it, then refining the scope of AdSense, also refining the scope of Google's general search, which was also based on the response of Google itself. So they not only take into consideration the responses of other stakeholders, but also the firm in question, Google. So which shows the depth of this stakeholder analysis. So I do think that this regulatory engagement part is quite an interesting aspect of the DMCCA. Now, just to put it in perspective, again, this is anecdotal, but responses to the European Commission, sometimes they never see the light of day. Because they get so many of them, they might be they have the potential of getting discarded. Whereas the responses to the DMCCA, to the CMA here, you can see that they play a pivotal role in how the CMA's own decision making changes. So this is quite impressive to say that within this time period, they are able to analyze the stakeholder responses and refine their initial proposed decision and change it according to what the stakeholders have said. So for me, the regulatory dialogue aspect, while I understand that it takes a lot of time, it does lead to a more thorough and well-informed decision. So I do see its merits. But having said that, I mean, the points you raise about the speediness, Tom, and maybe Oles as well, I think they do stand.
I want to look at this issue from the different perspective, from the perspective of the objectives of both regimes. And regulatory dialogue, it would be one thing to engage. So you have highlighted very clearly the issues of openness and the ability to listen and reflect and engage in communication with different stakeholders by both, indeed, the CMA and the Commission. I wanted to ask you, what is the not the ultimate goal, but should we reduce these regimes? So how would you perceive the objectives of this regime through the perspective of public enforcers in the UK, in the EU? Should we aim to just to pursue it on the kind of inductive bottom-up level, like case by case, by opening up one market we can contribute incrementally, and that's our mission and that's our reasonable limit, and maybe that's the limit of our ambition? Or rather, we have the overarching kind of broader strategic goal, which we pursue by doing different, so rather than bottom up, doing it top down. And thus, if the later, can we use regulatory dialogue, somehow making perhaps some compromises on the issues which are less important for that overarching goal, in order to somehow nudge the designated undertaking to be more collaborative in other aspects? Is it even doable if such broader strategic mission is there? Is it too naive? How do you see this kind of overarching picture framework of these regimes, Tom?
Yeah, it's a big question. So competition policy is part of economic policy. It's a kind of technocratic part with limited democratic legitimacy if it starts straying into into matters of public policy. No one's elected at the CMA, obviously, and they don't report. It's a non-ministerial government department. So the reason, when the Blair government enacted the Competition Act and the Enterprise Act, competition policy was kind of pushed out to the experts. I think rightly, for the most part. But now it's especially with the digital markets regime, it is inevitably more of a political thing. It's more part of public policy. If you're deciding a technocratic threshold in a merger investigation, that's rightly done by people kind of outside government with the right expertise. If you're deciding, hang on, where do we want the tech sector to go? That's much more difficult and much more political. But I wouldn't overstate the way in which this regime can set those kind of grand aims. A lot of it's about removing artificial restrictions. When Apple doesn't let an app developer tell a customer that they could get something 30% cheaper elsewhere, that's an artificial restriction. The CMA and other regulators want to remove that restriction. That is not some highfalutin kind of public policy thing that the Prime Minister should be setting. That's kind of normal competition policy. The other, so if you kind of remove the removal of artificial restrictions, however, will have a bigger effect than that, because it should be good for growth. I mean, it was news to me that this kind of stuff would be bad for growth, because it's really the opposite. If you are allowing other participants in an ecosystem other than the big tech firm to operate more freely, then that ought to be good for growth and good for British growth, because a lot of these app developers or vertical search firms or book publishers are British. So if you're talking about public policy in those terms, you should want those to be free to operate without monopoly rents being creamed off their revenues or without them being restricted from doing what they want. So yeah, it's a tough question. Verity, you probably got a better answer.
Well, I mean, like you say, it's a very big question that takes in a number of pieces, but maybe I might focus on the kind of final point you came to, Oles, which is around, you know, what's the role of kind of I think what you were asking was almost what's the role of a potential negotiated solution to some of these problems, you know, through regulatory dialogue, and I think that's actually really, really important. And I think what you can see with, I mean, what you see with the Digital Markets Act is obviously, you know, Parliament wrote the rules. Everyone's then said, as Tom was saying, you know, everyone has to say how they're complying with the rules, and then you have a fight over whether the rules are being complied with or not. There's no fight really to be had, although people are now, in the context of the review, having an argument about whether the rules should even be there. Are they the right rules? But that's not really the discussion. The discussion is about, are you, you know, strictly it's are you complying with the rules or not? And I think it's good that under the UK regime, there's actually an opportunity to have a discussion together with businesses, both the businesses that are potential SMS designees, but also with others who rely on them, you know, those kind of app developers, etc., that Tom speaks about what the right, you know, actually designing the rules. What are the right rules? What are the most important priorities? And critically, you know, what's the most effective way to achieve them? Of course, you know, there are some things which are, as Tom says, a bit more straightforward to design, but a lot of the challenges that these markets pose are very, very difficult to solve. You know, highly, you know, there are a lot of complex technical issues, and I think the best way to get to a solution that is, you know, that actually achieves the outcome that the authority, that, you know, that the government might want the authority to achieve, but, you know, achieves the kind of pro-competitive outcome, will be to do that in collaboration with the firm you're regulating. And I think, look, different businesses will take different approaches and have different levels of openness to engaging in that process with the CMA. But certainly, you know, my experience is that, you know, firms that are subject to regulation actually do like to participate in that design. And I think there is scope to, if you have a regulator that is behaving reasonably, to have, you know, some things that you can agree on, some things that you don't agree on, and then there's some space to meet in the middle and actually come up with a solution that really works and, you know, isn't a solution that's compliance on its face, but actually, you know, when you lift the lid, it doesn't achieve any of the objectives because the firm's found a way to kind of move the business around it. I think the way you can avoid that is through actually working in collaboration, and that's a real strength of the regime, that it allows that.
Thank you very much.
We'll have to wait and see, of course, exactly how it's implemented in practice, but, you know, certainly the early noises are that there is that level of cooperation. Of course, that comes with trade-offs.
Thank you. Anush?
Right, so I think I'd like to start my answer here by, again, going back to what the DMU keynote speaker, the senior director of the DMU had said. So in the conference, he'd explicitly said that Parliament hadn't provided any clear objectives for the regime apart from unlocking growth in the UK digital economy, which again, I think Tom and Verity have mentioned lightly. So we compare this with, say, something like the DMA, which has, I think, clearly established objectives, which are contestability and fairness, which form the first 10 paragraphs of the DMA as a preamble. So we have these different objectives to start with, whereas the DMA has this explicit set of objectives, and whatever they do in terms of their obligations are clearly instrumental in serving these strategic objectives. However, now we have the CMA who are able to develop their own method of finding what leads to unlocking growth and what is proportionate and effective intervention that would lead to unlocking growth. So I think this level of flexibility is quite interesting. And now the CMA is only bound by, say, the 4 principles in the DMU, which are pace, proportionality, predictability, and process. Now, as long as these 4 principles are adhered to, it's up to the CMA how they define what unlocking growth refers to. So it's quite interesting in how the CMA, as Verity mentioned, will take charge of this new legislation, and how interventions would take place within this regime. So I think I don't know if that fully answers this question relating to goals, but I think this unique goal of the DMCCA, which is just unlocking growth, leads to a wide array of possibilities, in my opinion.
Yeah, I mean, look, I also think just stepping back in the those of us who are expert in competition law and competition policy really like to focus on that, but I think we really can't lose sight of the broader context in which this operates. I mean, the fact is, with the AI revolution, we actually do, having sufficient infrastructure to be able to actually seize those opportunities for the UK as a country, and potentially then for the UK to be a leader that can, serve other countries. I think, that is potentially very critical to not only growth, but to to the UK's national security and a number of other things. So I think we can't be too precious about kind of being purely technocratic when the regime has to operate in the context of that reality and of the broader geopolitical reality that we live in.
Before closing this conversation and inviting you to share your recommendations with students, and maybe to also reflect on the issues which will preoccupy most of your time in the following months within the DMCCA, I wanted you Verity pick this issue, so maybe we can quickly reflect succinctly. I know that you are running out of, well, we have agreed for an hour. How do you interpret the latest announcements that big tech companies will be investing significant resources in the UK AI infrastructure? Is it and how what is the response from the European Union? Is it a kind of consent to be a farm club? Not so the ambition to play in Champions League is somehow put on hold, or it's a most realistic scenario where you just take an important role, start playing an important role in this global digital race. So how do you read this major development?
So when Google visited along with President Trump and other tech companies, Google announced a $5 billion investment in the UK, and we were all told we should be very grateful for that. Now, within the last couple of months, Google has announced a €5 billion investment in Belgium, and a $9 billion investment in Oklahoma, and a $7 billion investment in Iowa. So, these are just the numbers that these firms are dealing in. We are not special when they announce a $5 billion investment in the UK. It's not going to give us a world-leading AI industry that we wouldn't have otherwise had. Of course, we actually did have a world-leading AI company, but it was sold to Google. So, I don't think we should be too fooled by the kind of wider industrial picture of investment in the UK. Something that does attract investment, of course, is open markets. So competition policy is part of that. So let's not abandon all competition policy at the shrine of a data center.
Thank you. Verity.
Just a nice provocative note to end on, Tom. I mean, I think, look, I hear what you're saying. There are huge numbers thrown about in terms of investment in data center capacity, in particular AI data centers. And yes, that investment is not just in the UK, it's in multiple places around the world. But there is also, I think there is a global race to build out that capacity. And, it's not like it can only be built one place, but it's not going to be built everywhere. And so I think, there is, and if you're in a place where it's not built, then that means that either you're dependent on another country to be supplying you that kind of compute capacity, or that you simply don't have it, and that therefore you can't then the businesses in your country can't take full advantage of the opportunities that it presents. I'm absolutely not saying that all competition policy should be sacrificed at the altar of a data center, as you said, but I do think we need to, I think in the broader context of the essentially fourth industrial revolution that's happening with AI, that needs to, we can't conduct competition enforcement, competition policy in a silo. We need to take that into account. But I do think that what is very important to getting those kinds of investments is a level of, as you say, open markets. Of course, that's very important, but also regulatory stability. And one potential risk of having a regime that is as open-ended as the DMCC or as the strategic market status regime is that there is potentially a huge amount of uncertainty. Once you have the designation on the books, you can then go and, the CMA could go and do any number of things. So I think from that perspective of stability and certainty, I think these first steps that the CMA has taken with this new regime are very, very important. I think it is while people might be frustrated that it's not faster, not going kind of further and faster, I think it's actually really critical that when the CMA has such significant powers that it exercises those, especially in the first stages of the regime, in a way that promotes that regulatory stability and a sense of kind of certainty over at least the scope of what you're going to do with these very broad powers. So while I don't think that we should be, and I don't think doing that is kind of sacrificing competition policy to geopolitics. I think it's the right way for an unelected authority, as you say, to exercise what is really quasi-legislative power.
Thank you. Anush?
I think I'll just try to balance the two views and say that I think it is quite important that whatever action takes place, it shouldn't lead to chilling the UK's investment climate, because I think as a teacher of EU law, one of the fundamental things I'm sure you OLS do teach students is that learning EU law is quite important, because the EU is an unavoidable economic partner for the rest of the world just because of the number of countries involved. Now, once the UK stopped being part of the EU post-Brexit, the question arises whether the UK is still that unavoidable partner for other countries, or whether the UK needs to do enough to make sure that investments come into the UK, because now they don't have the backbone of the EU anymore. So that is a question I think we do need to concern ourselves with. At the same time, I think intervention is quite important, as Tom alluded to. So it is a delicate balance because investments are important to the UK's economy, but at the same time, without intervening, it might lead to damage that cannot be done away with later on.
It's always nice to hear the final words of philosopher about delicate balance. What will be preoccupying your interest in the DMCCA in the following month? And maybe combining two answers, recommendations for students who are interested in this regime. Tom?
Well, the coming months is about remedies in the first two cases, mobile platforms and search. So we're the devil's in the detail in these things. A few tweaks of language, one way or another, can render a remedy successful or a failure. So it's important stuff. So that's and then we're hoping, of course, for the third case to be opened in the new year. If the CMA is watching, I think it should be Amazon, but we shall see. So that's on the DMCC. Broadening it out to competition or more generally, I mean, you've got the Department for Business is now consulting on a review of the class actions regime, the collective actions regime. So the big tech lobbying circus has moved on to its next victim. So we'll see what happens there. I mean, it does seem early to be reviewing that when we've only had really one case finished since the new regime came into force. But we'll see. So that's going to take up a bit of time there on the kind of public consultation front. And then the CMA is doing fewer mergers, certainly fewer in-depth mergers than it used to. So that's less of a feature of the current kind of regime. And then more widely, the international picture is carrying on. Lots of countries are thinking of these digital markets regimes or implementing them. So that's a lot of fun that we can have around the world.
And recommendation?
Sorry, a recommendation for students. Yeah. Well, I suppose that, I mean, this is the, a new regulated industry, really. When an industry becomes this important, it tends to end up regulated. So it shouldn't it shouldn't be a surprise. But it's really the dawn of all that stuff, and it'll run and run like telecoms did when it was first started getting regulated decades ago. So I think it's a great area for students to take an interest in. I've always thought it's a fascinating area, and there should be jobs in it at the end of it, hopefully.
Thank you. Verity?
Yeah, so I mean, Tom, I think you've kind of ticked off most of the highlights that are coming from a competition law perspective. I think maybe stepping back from a more general perspective and thinking about the way markets are evolving, one thing that has been actually quite fun for me is seeing some of the what I might call defense side arguments about the way that competition might operate differently in AI actually kind of playing out in real time. Often, if you're talking about a merger, for example, and what would happen with or without the merger, you kind of you only get to see one side, depending if the merger happens or not. You never know what would have happened otherwise. And around this time last year, when there was a lot of talk about AI partnerships, there was a number of people were saying, actually, large language models, generative AI doesn't have the same market features as other kind of Web 2.0 tech markets that have tipped in favor of one or two large incumbents. And I think just seeing the huge explosion of competition in that space over the last few years, but the pace of acceleration has been huge even over the last 6 months. That's actually really, I think that's really exciting, and seeing how people are using that technology. And it's the kinds of things that were being said by who Tom might cynically call defense side people who are acting for larger tech companies, saying that actually we don't think this is a market that's tipping in favor of, say, one LLM, because actually people are going to use different LLMs for different purposes. And actually seeing that really happen over the last little while has been exciting and pleasing. And I think I'm excited to see that continue to evolve, the technology continue to evolve over the next year. Even a year from now, I think it will be in a very different place to where we are today in terms of adoption, and it's going to change the world. So I guess the already has changed the world, will change the world even more. So I guess to say something different to Tom, for students, I think I would really encourage anyone interested in this space to try and understand how the technology itself is evolving. There are a number of really excellent analysts who you can read who talk about competition in this space, all the really fascinating geopolitics that's relevant to it as well, much way outside the realm that we've been talking about today. So if you're interested in this space, try and understand the tech. That would be my advice.
Thank you very much, Verity. Anush?
I think, again, taking both views into consideration, personally, I'm quite interested in looking at the DMCCA's procedure and how they carry out conduct requirements, how pro-competition interventions, which is something we haven't talked about, but is an important tool that the CMA has, take place in the future. So that's something that I'm quite looking forward to see how the discussion on that develops. But on markets themselves, I think it's a very key point that Verity makes, because we do need to understand these markets quite well. We need to understand AI markets. We need to understand what is generative AI, what is agentic AI. Now we have this this whole this wide area called agentic AI, which we haven't even touched upon in terms of, let's say, competition, because it's so new. So there'll definitely be something that does take place in that realm in the future. So I do look forward to seeing what that does mean for competition lawyers and lawyers in general also, because I think this whole realm is quite interesting and so new that we can't be quite sure what will happen. But coming to the law in itself, I think it's important that we do take an approach that makes sure that the law can be future foolproof as well, not making sure that it doesn't stifle any sort of innovation. But at the same time, I think one final point I wanted to make is different jurisdictions that Tom had mentioned. Now, the UK's DMCCA model is something that many other jurisdictions, for example, India, could look at and try to develop their own legislations based on. Because I feel having a prescriptive approach like the DMA does not work for many countries like India, where the issues are different. So having this unique bespoke approach might be the better solution for many other jurisdictions. And I think that's why I find the DMCCA's approach quite unique and useful, because I think it is a template that many countries in the rest of the world can look at and see that, okay, this is something that we can take our regimes forward as well, because a prescriptive approach might not be for all.
Any recommendation?
Any recommendation for students? I think it would be quite important to understand all these new technologies quite well before you engage on, let's say, how competition law or digital markets law apply to them. So I think that's one of the fundamental aspects. I think competition law has evolved to not just looking at competition in a general sense, how it used to exist in brick and mortar. Now we do need to understand the nitty-gritties of these different firms and how and the nitty-gritties of these markets. Without that, we might end up with either over-enforcing or under-enforcing, and which is basically errors on either side. So to prevent that, we do need to understand these markets well. So I think that would be my fundamental recommendation to any students.
Verity Egerton-Doyle, Anush Ganesh, Tom Smith, thank you very much indeed for this really engaged conversation.